liable for negligence because the explosives in here were a superseding cause. They owed a duty of care to the people in the zone of harm. Mrs. Palsgraf was outside the zone of harm. Well, then you might ask, if you've read this case in the book or looked it up, why did the court hold the Long Island Railroad liable in the early 1900s? Simple reason. It's what's called a results-oriented decision. Long Island Railroad has a lot of money. Mrs. Palsgraf doesn't. The jury felt sorry for her. So they twisted things to reach a decision that was against the Long Island Railroad to help the most innocent of all people here, Mrs. Palsgraf. In this day and age, today, the case would not be decided that way because it's outside the zone of harm, therefore not foreseeable. And again, the explosives act as a superseding cause. Well, while this may not occur on an everyday basis and is a rare case, negligence is a very, very important concept to understand because in the business world, executives, CEOs, CFOs can make negligent statements we call negligent misrepresentation. Let me give you an example, okay? In the biotech world, if a CEO is trying to pump up a stock and he's at a conference with a whole bunch of analysts and he's asked questions because the company's cash balance is starting to dwindle, okay? And it's a small biotech, and in the biotech world, small biotechs need licensing agreements with big companies like Pfizer or Merck in order to succeed, to bring their drugs to what we call commercialization, to eventually get their drugs approved and be able to sell them. Well, if this company, let's say, is running out of money, CEO makes a statement that we have partnerships talks that are heating up. We expect a partnership to be signed any day now. And he's doing that to drum up the sale of, or the stock, for the stock to rise and for investors to feel secure. The question is that negligent behavior or is it fraudulent behavior? In the previous part of the chapter, we covered fraud, which had 6 elements. We had an intentional misstatement or omission of a material fact upon which the plaintiffs justifiably relied on, thereby causing their damages. In this case, do we have an intentional misstatement that partnership talks are in progress? Well, let's say the partnership talks didn't result in a partnership agreement and the company's cash balance continued to go down. As a result, the stock continued to go down. And people bought the stock based on the CEO's representation that they were going to sign a partnership agreement. Stock tanks when they learn partnership talks are off. Well, the CEO, one could argue, really believed that the company was going to sign a partnership agreement. So can we say he committed fraud? One could argue no, if he believed that it was going to result in partnership agreements. But one could argue he committed negligence. Maybe he should have waited until the partnership talks resulted in a partnership before he said anything. And actually, it is corporate policy in a lot of companies that they will not comment on partnerships, mergers, or acquisitions because they have to wait until the transaction is actually signed, sealed, and delivered. Because if it doesn't happen, shareholders can actually sue for making a negligent misrepresentation. Well, let's go through the elements. Does a CEO have a duty of care, okay, not to make statements that aren't true or statements he can't solidify yet? The answer is yes. In this case, we can say he breached that duty of care. Did it cause damages? Did the shareholders buy more shares, or a future shareholder decided to buy shares based on the representations of the CEO? In this case, we could argue yes. Stock tanks. As a result, these shareholders lose money. In that case, we have a case for what's called negligent misrepresentation, and the shareholders would be entitled to get their money back. One might be able to argue it was fraud if the CEO knew that those talks either weren't happening, partnership talks, or they weren't going to result in a partnership agreement. Then you could say he committed fraud. Okay? So we can assert 2 causes of action. We can go after fraud first, which is the higher level of culpability. Okay? And if we don't get that, we can at least get negligence. And negligent misrepresentation occurs quite often in business. The other area, for some of you who are thinking about it being an accounting major, which I highly recommend, is the best way to start a business career. It leads to a lot of options in business. And if you're interested, send me an email and we can chat about it online, or we can talk about it on the phone or via email if you wish. As a CPA and a lawyer and a finance guy, I can say that being in accounting, an accountant has the best advantages coming out of college. But auditors who are accountants are held to high standards of care, and negligence and fraud are two of them. And that's something that you will learn a great deal about when you take commercial law, which is the second part of this course, Business Law 316. So keep that in mind. We cover a lot of the roles and responsibilities of directors and officers, accountants, corporate governance issues. In addition to corporate governance issues, we're going to create an entity together, be able to choose what form that entity should be, whether it's a partnership or the 4 types of corporations. Once we form the entity, we're going to get into operational issues, which relates to the Uniform Commercial Code and sales transactions. We're going to actually do sales transactions together. Once we've done that, we're going to get into issues such as how to protect the property rights of the company, intellectual property, which we've covered a little bit in this course, but we're going to go into a lot more detail. And then we're going to get into bankruptcy issues, how to expand a business through mergers and acquisitions and franchising. So commercial law is a big step up from this course, and it really ties everything together in the entire business curriculum. I highly recommend that you take it. I will be teaching it in the spring. And for me, if you picture a wheel, it is the center of the wheel, connecting all the different disciplines of business. Business Law 215 and Business Law 316 really tie everything together. I hope you're having a good day, and I'll see you on the discussion board.